All right, thanks so much for being with us here on Atlanta News First Plus. I'm Joy Lim-Nakarin here, joined by attorney Jay Edwards Ship. Thanks so much for being with us, Mr. Ship.
Thank you for having me.
So, we wanted to get on here today just to discuss some breaking developments surrounding the Georgia case against the former president, Donald Trump, and 18 of his allies or co-defendants. And within just the last few hours, we have learned that the former president, his team, has entered a plea of not guilty. And in addition to that, they have filed a waiver so that, the hope there is that he would not have to appear at his arraignment. His arraignment set actually for Wednesday, September 6th. It was set for 9:30 in the morning. And Mr. Ship, just kind of breaking down, arraignment is essentially where the charges are read aloud, and the defendant actually enters their plea, guilty, not guilty. In this case, he's gone ahead and entered that plea of not guilty, and he has filed that waiver. The judge still needs to sign off on it. What else do we need to know about this?
So let's break it down, start with what an arraignment really is. It used to be back when, people weren't as literate as they are today. And arraignment was just what you said, where they do a reading of the indictment or the accusation and tell the people, okay, this is what you've been charged with. You have an opportunity to enter a plea of guilty, not guilty, nolo contendere, which is no contest, and, just kind of, have a chance to kind of see what you got ahead of you. In this particular case, or in this particular day and time, an arraignment is more like just an administrative thing. You get it. A lot of people like to waive it because they don't want to sit in court all day waiting for their name to be called. I'm pretty sure these 19 defendants all don't want to be sitting in the courtroom with their lawyers trying to wait for their name to be called along with everybody else that's on that particular calendar. There might be security concerns considering the magnitude of the case and who is actually involved in it. So it would probably be in their best interest to enter what is called a waiver of arraignment, just saying, hey, I'm not going to show up, but here's my plea. And, that gives them the opportunity to kind of get started on the discovery process, kind of see where their next move is.
Yeah. What would be the reasoning to waive arraignment? I mean, just kind of, we're here typically to do a legal discussion, but just from kind of a political perspective or an optic standpoint, typically people waive arraignment when they want to avoid publicity, right?
Right.
So it's a little bit of a surprise knowing what we know about the former president. Is that right?
That is a big surprise coming, from me. I was under the impression that he would seize any opportunity to, kind of campaign or use this as a campaign event, seeing that he's just saying, okay, well, I don't feel like coming to Atlanta at 9:30 a.m. It's kind of surprising, but many times, people will just show up, if not for publicity, just to kind of, get a feel of what type of prosecutor they're dealing with.
Yeah, and I wonder what the reasoning for all this would be, just because, we know that the former president has been on the record in the past saying, all I need is a fourth indictment, essentially, to win the 2024 election. So it is something, I mean, the arraignment could have potentially been something that might have been a publicity opportunity in some people's minds. But I want to point out also that we also learned just within the last hour or so, less than that, that the judge has decided to allow the media to be in the courtroom for the arraignment on September 6th. And again, that was when, Rudy Giuliani, Mr. Trump, and all 19 defendants were set to be arraigned. But the judge is now allowing electronics, allowing the media to be in there, which is something that we did anticipate. So I wonder if that makes it more surprising that Mr. Trump has decided to file for a waiver, or is that, or do you think, what's the reasoning?
So, it could be a situation in which he doesn't control the narrative. When you're stepping into, a court of law, Fulton County Courthouse, there are rules and regulations. Bailiffs are going to make sure that you don't have, outbursts, and in this case, it would probably be some type of political outburst. So, you get this idea that maybe he did a cost-benefit analysis on it and said, okay, maybe it's not in my best interest to show up, because again, we're looking at a situation in which Governor Kemp has already, said, I'm not going to call a special session of legislation just to try to sanction District Attorney Willis for bringing this case. So it's kind of telegraphing to Trump and his supporters that this is not their ball game anymore. This is a different avenue for them, in that they don't necessarily control the narrative at this point. So it's probably, him saying, yeah, since I can't control the narrative, I just won't show up.
Yeah, that is very interesting. And we know that Sidney Powell and some other defendants also filed for waivers as well. Mm-hmm. Is that kind of similar rationale, or maybe is it just geographic inconvenience traveling, or what do you think?
So it could be geographic. Also, Sidney Powell filed for a speedy trial. She's trying to get this heard as quickly as possible. It could be one of those situations where she's just like, let's move this as quickly as we can. Let's not show our hand by saying, yeah, we'll show up for an arraignment, but yet we're filing for a speedy trial. That just adds more time for her lawyers to not actually be in their offices working on the case. So
because it's just more efficient if they can do it. Exactly. If they can avoid the appearance, the arraignment.
Exactly.
Okay. But that said, the arraignments themselves are supposed to be very quick. It's supposed to be, I'm going to actually pull up, because we have this on our website, mm-hmm. So that people can actually see the schedule. It was supposed to be that the former president was going to go first at 9:30, and we have so much on our website actually.
Wow.
But I want to just point you to this, because initially this was the case, that we had this whole schedule lined up.
Okay.
Where at 9:30 it was Donald Trump going to be arraigned. At 9:45 that morning, Rudy Giuliani would be arraigned, and John Eastman at 10 a.m. and Sidney Powell at 10:15, and on and on and on. In just 15-minute intervals, this was going to happen throughout the day. And then little by little, we've seen several of these defendants say, hey, you know what, I don't want to go. Let's see, do you anticipate that the judge is going to sign off on this waiver?
Yeah, most likely it's going to be a non-event. Judge McAfee is pretty much known as a fair guy. He's probably going to just go ahead, sign off on it, allow them to waive it. What we have here is a situation these defendants are not supposed to be discussing the case with each other. And even when you kind of stagger them out on 15-minute intervals, there still is a possibility that they could, meet with each other and kind of, discuss the case. So this may work out for District Attorney Willis's office as well, because it doesn't give them, the look of them coming in and kind of, getting their stories together and kind of figuring out who's going to take what plea, this, that, and the third. It allows for them to not necessarily even come to the courthouse unless, motions are being heard or it's time for trial. So, this is a win-win for both sides, I believe. You don't have to worry about it being a campaign event on District Attorney Willis's side. And then for the Trump 19, it allows them to, not have to worry about showing up to Atlanta, showing up to court, even when they turn themselves in, or President Trump turned himself in. He was met with, some supporters, but he was also met with some people who, protested his presence. So, it's not going to be a friendly atmosphere all the way for him. And, he's big on appearances. The idea of having protesters there at the courthouse at the time that he comes in for arraignment may not be what he wants for his campaign.
Yeah, and I also just want to point out that this is another new development on our website right now. I want to point our viewers to this, that Governor Kemp has declined to have a special emergency session. He's saying, I'm not going to have a special emergency session. Remember earlier this month, there was, let me show you the tweet that essentially lays it out. This Republican Senator Colton Moore, he wrote, as a Georgia state senator, I'm officially calling for an emergency session to review the actions of Fani Willis, the Fulton County DA. America is under attack. I'm not going to sit back and watch as radical left prosecutors politically target political opponents. Well, Governor Kemp has responded saying, I'm not going to have this emergency session. And he says, quote, you can read it right here on our website. Up to this point, I've not seen any evidence that DA Willis's actions or lack thereof warrant action by the prosecuting attorney oversight council. That's what he said during a news conference. As long as I am governor, we are going to follow the law and the Constitution regardless of who it helps politically. So that's not going to happen. Obviously, there's been a lot of discussion among Trump supporters, critique of Fani Willis. And many Trump supporters do say that the prosecution is politically motivated. So there you have the governor taking a hard stance on that, we don't have any questions about whether this is on the up and up or not. What do you think about that?
So, this is the same, I believe he's a representative who comes out and says, he doesn't want to have to get his rifle. He doesn't want America to devolve into civil war. And, there's a lot of talk about civil war in America right now, which is frankly something no one wants to deal with. I mean, we've seen it in other countries numerous of times, how civil war is not, the call of duty that a lot of these people are thinking that it would be. It would be, terrible for all people involved in the U.S. So, this guy is most likely just a Trump supporter who is, trying to get his constituency to believe in him, doing what he can to kind of make a lot of noise. Again, you have cooler heads that prevail. You have Governor Kemp, who pretty much said, the election was not stolen. It was, on the up and up. He's already said this. So he's going back to the Constitution of Georgia, which says, we're going to have that separation of powers, and we're not going to, just have a special session of the legislature just so we can, try to remove this duly elected district attorney. So, I'm glad to see that Governor Kemp is doing that by stepping in and saying, okay, hey, I'm going to be the cooler head. I'm going to be the wiser individual. And I think it's pretty dangerous for, certain individuals to keep drumming or having this drumbeat of civil war when we all know no one wants that in this country.
And, just to kind of give a little bit of context, it's important to remember, on one hand, Governor Kemp is a Republican, but on the other hand, there was a lawsuit, Trump v. Kemp, related to this, alleged, what this whole case that we're talking about, which is when Trump's, one of his legal teams went after the governor because they claimed that there were issues with the election, that essentially that Trump should have won the election.
Right.
So there's definitely some history, some bad blood.
Yeah. I mean, Trump did actually try to campaign against Kemp when he was running for re-election. So, you got that in there as well. And seeing that he's not going to, kowtow and say, okay, I'm going to go along with this just because this is mob rule. They want to take away this duly elected prosecutor. It speaks volumes about his character, and, I'm just glad to see that happening.
Yeah, and just want to point our viewers to that story on AtlantaNewsFirst.com. And, when you go to AtlantaNewsFirst.com, you see how there's that tab, Trump Investigation, and that's where you can find all of this. And we've organized it so it's in chronological order. You can see all the updates as they come down. And, interesting that Mr. Trump, you can see one of the headlines, has protested the speedy trial attempt by the DA, Fani Willis. What do you think about that? Because, initially this started with a speedy trial motion for, I believe it was Kenneth Chesbro's team who filed for that.
Correct.
And then the judge basically granted it, and you know, Fonnie Willis was on board and set that proposed trial date, said, okay, I'm ready to go.
Right.
And then Trump's team went back and filed a motion to oppose it, right?
Right. I mean, this is the team that tried to get his federal case heard in 2026, I believe it is. So now we're seeing that, as I've said many times, his whole thing is to delay. And in this particular instance, it's looking like he won't be able to try those same things. So now he's trying to, protest it starting that early. He's also trying to remove it to federal court. I'm sorry, go ahead.
No, I didn't mean to interrupt.
Yeah.
It's pretty typical, though, that defense teams will just try to delay, right?
Yeah, a lot of times delaying can be good. People's memories get foggy. Things become a little bit kind of murky. Some agents may be fired or they may transfer to other jobs. It may become, hard for them to show up to court. And that delaying tactic sometimes works out in the defendant's favor. In Mr. Trump's, case, in a lot of his cases, even before he was president, it was always, let's just outspend the other guy, and we can hold them off if we outspend them by delaying the administration of justice. In this particular instance, he's up against, the state who has unlimited resources and has pretty much said, okay, well, we're ready to go. We're ready to move forward. And I think that this is, a new avenue for him because he's never experienced a situation in which he has had to go against, the state who has unlimited resources, who, is willing to prosecute him for criminal charges.
Yeah, absolutely. I also want to talk a little bit about Harrison Floyd, who's now out on bond. And, initially, and he was the only Trump defendant who was, or, Trump case defendant who was held behind bars. He's now out on bond set at $100,000. Or I should say a bond agreement was reached is how I should say it. But at any rate, he was the director of Black Voices for Trump. He has insinuated that, the jail and that the prosecutor's office is racist because it was the only defendant who was held on bond, who was behind bars, I should say, who was held at the jail, and who did not arrange a bond settlement to turn himself in. And he was also the only black male defendant in this case. But I guess there's a little more to the story is what we've learned.
Right.
Tell me a little bit about why he was behind bars.
So when he did have his first appearance, the judge in that case decided that, he was a risk to attack another FBI agent, as he had already done. He had been approached by FBI agents for a similar case, I believe it is. And at that time, he pushed them off and, physically pushed them away and questioned who they were even after they showed their badges, this type of thing. So he showed that he doesn't necessarily have a good grasp of, how law enforcement works in these particular instances. So the judge decided, okay, based on this, since you're already facing charges for that, we're going to deny your bond at this time. Now, the question is, if a person volunteers themselves to the court by turning themselves in before the headlining defendant, are they really a flight risk? Are they a risk to flee the jurisdiction? That's a big question. And this particular judge found that he would be a risk to flee the jurisdiction based on the charges as well as his history with law enforcement. I can't necessarily say whether or not it was the right decision, but again, we have to look at this guy came in with no counsel. He never had to, worry about talking to counsel to try and set up this consent bond agreement. So he came in by himself pro se, and now he's complaining that he doesn't get the same treatment as the people with a lawyer. And I don't think it was in his best interest to try to play the race card when you have a black DA who is actually prosecuting this case. It's not going to play out well for him.
Okay. Yeah, no, it's an interesting point. So what do we expect now that we've got less than a week until what was supposed to be the arraignment for most of these defendants? September 6th, Wednesday, September 6th is when we were expecting the arraignment for Mr. Trump and most of these other defendants to take place. But, again, Mr. Trump is waived.
Yeah, they'll probably give them a scheduling order, tell them, hey, this is when you need to turn in your discovery. This is when you need to kind of be ready to argue your motions, or this is when your motions should be turned in. All of this will probably be worked out with the prosecutors in this case, and they'll probably come to an agreement to kind of figure out where they go next. That's the good thing about having an arraignment and showing up to your arraignment, is you get a chance to talk to the prosecutor and kind of figure out, okay, what is the state looking for as far as a plea deal is concerned? And I'm pretty sure they haven't, spoken with them about that yet. If they were to, attend, they would kind of see what the state is looking for as far as jail time or fines or anything like that, if they wanted that. So, with them not doing this, I'm pretty sure they have been in contact with them, but there's nothing like that face-to-face meeting, to kind of get a feel of what you're up against. And, in the meantime, they'll most likely just be preparing their motions, getting ready to file those, and just getting ready to argue those motions when it's time to do so.
Yeah, absolutely. Attorney J. Edward Shipp joining us. Thank you so much for sharing your insight and analysis.
No problem. Anytime.
Yeah, we so appreciate it. Actually, let me put up, before we let you go, I just want to put up your name super so that people can see how to get in touch with you, because I know we got a lot of people asking, who is this gentleman?
Who is the guy with the bow tie? It's me.
Yeah, so
I
tell
am
people
him.
how can they reach out to you?
They can reach out to me, J Shipp Law on Instagram, JAYSHIPP on Facebook, JShipLaw.com on the internet. Easy to find.
All right, but don't believe everything on the internet.
Right.
All right, look, I want to bring in my colleague who runs our weekly political update, Tim Darnell, who is, a political reporter, particularly for our digital media platforms. He's got a lot more on kind of the political aspect of all of this. Tim.
And thanks to all of you for staying with our live stream here on Atlanta News First. I'm Tim Darnell, bringing you this edition of Political Update here on all of our streaming platforms. As you've been watching for the past several minutes, we all know now that former President Donald Trump has indeed entered a not guilty plea in Fulton County earlier today, just a few moments ago, perhaps maybe 1 or 2 hours ago when the story first broke. The former president's attorney, new lead Georgia attorney, Stephen Siddall, entered a not guilty plea in Fulton County Superior Court earlier today, and also filed a document formally notifying Fulton County Superior Court Judge Scott McAfee that he is waiving his September 6th arraignment date. The latest in several of the co-defendants to do so, also Sidney Powell and Kenneth Chesebro, have also entered, and Ray Smith III, have all entered not guilty pleas and waived their arraignment dates. Arraignments are set for less than 1 week from today, Wednesday, September 6th, beginning at 9:30, but we fully expect that more defendants will enter not guilty pleas and also waive those arraignment dates. We also know that earlier today, Georgia Governor Brian Kemp dismissed the notion of calling for a special legislative session that several weeks ago, earlier this month, State Senator Colton Moore sent a letter to the governor requesting that he call a special session this fall to consider sanctions or perhaps even disqualification of Fulton County District Attorney Bonnie Willis over her sweeping indictments 2 weeks ago that brought criminal and felony charges against the former president and 18 of his Republican allies for their alleged attempts to overturn the lawful results of Georgia's 2020 presidential election. State Senator Colton Moore was also praised last night, on Wednesday night, on Donald Trump's Truth social media platform, saying that the state senator from Trenton, a Republican from Trenton, Georgia, should be praised and lionized for his stance against or opposing all of these sweeping historic indictments that came down 2 weeks ago from Fulton County District Attorney Bonnie Willis. We also are awaiting results or awaiting a motion or a hearing or a decision, I should say, from U.S. District Court Judge Stephen Jones from the U.S. District Court of the Northern District of Georgia. And we are awaiting a ruling from him per a request earlier this week from former White House Chief of Staff Mark Meadows. Meadows is one of several co-defendants who are seeking to sever their cases from Fulton County's indictment, which would happen in a trial in state court, and hoping to move his case into a federal court. Now, this is all based on the federal law's so-called supremacy clause. Meadows and his attorneys are arguing that any orders, any measures that Meadows undertook while he was Donald Trump's chief of staff during the tumultuous latter days of 2020 and into the early days of 2021 and the aftermath of the presidential election should be immune from any sort of state or local superior court prosecution because they were carried out while Meadows and others were federally constituted officials acting under the orders and the direction of the constitutionally elected president of the United States. At that time, that was Donald Trump. Now, I had a conversation a few days ago with Emory Law professor Jonathan Nash, who gave us some very interesting and insightful comments into the chances of Meadows actually being successful in his quest to move his case out of state court and into a federal one, and what kind of precedent this could set should Meadows be successful in this endeavor. And here is that interview. On Monday, former White House Chief of Staff Mark Meadows appeared before a U.S. District Court judge for the Northern District of Georgia here in Atlanta, requesting that his indictment, which was issued 2 weeks ago by Fulton County District Attorney Bonnie Willis, be removed from Fulton County Superior Court and moved into a federal court. And we're talking today with Emory Law professor Jonathan Nash. And really, Professor, I'd like to hear from you. What are the reasons that the former Chief of Staff is making this request, and what kind of implications will it have if he is successful in this endeavor?
Good questions. And I guess I would say there are different changes or certain differences between proceeding in state court as opposed to federal court. One is, it is a venue change. So the trial would take place in federal court, not in state court. And that has a couple of different ramifications. One is the presiding judge would be a federal judge. That's somebody who is an Article III judge, presumably somebody appointed with life tenure. Sort of the idea behind that is to make the federal judiciary sort of above politics, or give it a degree of independence to federal judges. In state court, of course, you'd have a presiding judge who is a Georgia state judge, a Georgia judge. The other difference, one other difference, important difference, I think maybe more important than the judge, is the jury pool. Fulton County, if the case proceeds there, you have a jury pool drawn entirely from Fulton County. Whereas if the case is removed successfully to federal court, and that's where the trial takes place, the jury is drawn from the Northern District of Georgia, the Atlanta division of that district, which consists of, I think, 10 counties in North Georgia. And some of those counties voted in 2016 and 2020 more for Donald Trump than did voters in Fulton County. So if you're sort of doing random draw, you might think that you're going to get at least up front, potentially more favorable jury pool in federal court if you're Mark Meadows. A last point that could make a difference, it's hard to know. Well, one thing we do know is that if the trial took place in federal court, there's almost no chance that you're going to have anything televised. Federal courts just simply do not do that. And we have an example of that today. Whereas in state court, it seems that that's a much more likely proposition. Now, whether Meadows and his attorneys are thinking about that aspect as opposed to any other, my guess is the jury pool might be the biggest thing. One last thing to mention, part of the reason that we have this statute under which Meadows and his attorneys are filing papers to remove the case to federal court is concern, which may not be present in this case or certain cases, but over time, concern that state courts might simply be biased against federal officers, federal officials who appear before them. So you might think that the federal court might give a more neutral forum to have the case heard.
Do you believe that Meadows and his attorneys are also hoping that if their case is moved to a federal court, that their chances of actually having the entire charge or charges dismissed and thrown out might be greater in federal court as opposed to Superior Court in Fulton County?
So that is certainly a possibility. One of the requirements that the Supreme Court has said has to be there in order for you to be able to remove, for a federal officer to remove a case to federal court, is that the defendant have a federal defense to the charges, some form of federal defense. So you might think that a federal court would be more likely to hear his arguments and maybe grant those arguments. It's and that again goes to this idea that the federal court might be, or it can be seen to be, sort of more open to arguments under federal law than state courts. Again, I don't want to suggest that the Fulton County courts in any way wouldn't do a fine job with the case, but that at least is the history behind this statute. And it might well be that Meadows and his attorneys think in this case there's some of that might actually ring true. At least they might think so, and they might get whether you think a better outcome or a quicker outcome in federal court as opposed to state court.
Give me your overall thoughts as far as the argument that Meadows and his attorneys are making, that as chief of staff in the Trump White House, he was simply, quote unquote, following orders from the commander-in-chief and the constitutionally elected president of the United States. He was simply following federal orders, and therefore should be exempt from any prosecution. Is there any legal legitimacy to that, or am I mischaracterizing what's going on?
Well, I guess I'll break it into two questions. The first is there a right to remove to federal court? And then second, is the defense valid, which he, I suppose, could still raise in state court if the case were to remain there. And I think he certainly, he was a federal official. It's, you know, that's sort of in this case clear. And there are some other defendants who are trying to remove, who were, let's say, alternate electors, at least that's the claim, and they claim maybe that qualifies them. That to me is much less clear. But Mark Meadows is clear. He was a federal officer. And then your question gets to the heart of it. Was he acting in his official capacity as a federal officer, sort of under color of office? That might be the terminology that we might think of when he did the things that are alleged in the criminal complaint. And here, my understanding is, of course, none of us, at least I was not in the courtroom today, so I can't know exactly what happened, but there were some questions about that. Was he acting as President Trump's chief of staff in sort of setting up meetings? But what if those meetings were really about the success of the campaign and the election as opposed to the president's official duties? So I think that's where the district attorney in Fulton County is trying to go with this, to try to make the argument that he was not acting under color of office. And his response would be that, in fact, he was. So how that will shake out, I think, is the $64 question. It's I wouldn't want to hazard a guess on it. I definitely think it's a valid argument, and it is not a frivolous argument at all. How it will ultimately play out, like I said, I'm not sure I would place money at this point. There just haven't been that many instances like this.
Yeah, we're totally in uncharted waters at this point. But let's say hypothetically, if Judge Jones from the Northern District of Georgia federal court does indeed grant Meadows' request to move his case from state court to federal, does that set a precedent? Do you foresee the former president himself making a similar attempt?
So just to let you know, you froze up a little bit there, but I think you're asking whether
yeah, well,
I don't know if Meadows was successful or not.
If Judge Jones does grant Meadows' request, will this set a precedent? Do you foresee former President Trump himself actually perhaps making a similar motion? We've heard rumors that this is something that is on the president's legal team's agenda. We haven't seen any confirmation yet. But could this happen if Mark Meadows is successful in his attempt?
It certainly could happen. One thing to note is it's not clear whether a successful removal by Mark Meadows brings the entire case to federal court anyway, in which case whatever President Trump would or wouldn't want to move for or try for might already be affected. But yes, it certainly is possible. I don't know whether his attorneys are waiting to see how this plays out to get an inkling for what the judge's disposition might be or what the district attorney's arguments would be. It's possible also, of course, that the president and his former president and his attorneys are sort of balancing things and still deciding whether they would prefer to be in federal court or state court. I mentioned before, just I don't know, I can't imagine this would really drive things, but that I mentioned that in federal court you would not have televised coverage. Maybe you would in state court, and given how the former president has conducted things in the past, that might actually, maybe he and his attorneys would prefer to have a more open access trial. I just don't know. So the short answer is sure, quite possible that they're contemplating it, and it wouldn't surprise me if they did it for all the reasons we spoke of before in terms of jury pool and judge. But to the extent that each defendant has an option to do it or not, there might be some calculation that they're making and thinking about it, or just taking a wait and see attitude.
We are talking with Emory Law Professor Jonathan Nash on former White House Chief of Staff Mark Meadows' attempt to move his indictment out of state court into federal court. Were you surprised when you saw all of the indictments come down 2 weeks ago from Fulton County District Attorney Bonnie Willis? Were you surprised at the number of defendants named in this indictment? You know, this is the most sweeping indictment we have seen thus far of the former president and alleged attempts and alleged criminal conspiracies. Were you surprised at the depth or the number of defendants involved in this?
Um, I guess I was, yes. Certainly, as you point out, it goes beyond what we've seen in other cases that are being lodged against former President Trump and some of his allies. There's been some suggestion that the special counsel in on the federal side sort of was looking at things as a more um, targeted approach, and maybe an approach more likely to get results at the end of the day. I don't know. On the other hand, we know that the DA here has taken a lot of time to talk to people and go through evidence and have the grand jury look at what had transpired. So maybe there's some thought that with a lot of defendants, you're going to get one or more defendants to turn evidence, sort of agree to a deal and testify in some fashion. But this is definitely a very large number of defendants, and it's a complicated indictment. I mean, there's a lot of a lot of things that are alleged there. So it took a while to get there, and maybe that's why it took a while to get there.
And we don't see any end in sight. This is something that's going to continue probably from now through the end of the year and into next year. From an overall standpoint, I mean, how long do you think all of this is going to, how long will all of this extend?
Another excellent question, and very hard to know. Again, it's a complicated case. If in fact some of the defendants are able to remove to federal court and others stay in state court, you wind up at that point, you're going to wind up having sort of bifurcated trials, and you have some defendants in state court who have asked for speedy trial. It's possible that those defendants go earlier and others go later. So you could get a lot of different things on a lot of different tracks. Also, whatever the timeline the judge, whoever the presiding judge or judges wind up being, whatever timeline they want to go with, some of these defendants, most notably former President Trump, are facing other criminal proceedings. And I don't think you can really conduct any two of them at the same time. It's just going to be just too complicated and just logistically not going to work. So that also could wind up extending how long, it's hard to know which one, but sort of extend the timeline for all of these litigations to work their way through the different court systems.
That was my interview with Emory Law Professor Jonathan Nash, talking about whether or not former White House Chief of Staff Mark Meadows will be successful in his attempts to move his indictment out of state court and into a federal court. This is obviously related to the historic sweeping indictments that came down 2 weeks ago from Fulton County District Attorney Bonnie Willis regarding former President Donald Trump and 18 co-defendants, including Mark Meadows, for allegedly attempting to overturn Georgia's 2020 presidential election results. Now, the nation's 45th president continues to remain a polarizing figure, not only nationally, but here in Georgia, and an organization calling themselves the Republican Accountability Project earlier this week launched a 6-figure ad buy in Atlanta and 5 other major markets, as well as have launched a billboard campaign in Times Square in New York, highlighting former President Trump's more than 90 felony indictments since he left office. And Gunnar Raymer, who is the political director for the Republican Accountability Project, talked with me earlier this week about how he believes the Republican Party needs to move on from the former president and what could be in store for the Republican Party and the nation in 2024 if there is another presidential nominee other than the nation's 45th president. Here's that interview. On Monday, the Republican Accountability Project launched a six-figure ad campaign highlighting the numerous legal challenges and indictments facing former President Donald Trump. And one of the markets in which this ad is running is here in Atlanta. And we are talking with Gunnar Raymer, who is the political director for the Republican Accountability Project. And really tell us what this organization is all about.
Yeah, so Republican Accountability Project launched after January 6th. We're a group of Republicans and conservatives who dislike Donald Trump's takeover of the Republican Party. We think that what happened on January 6th, leading up to January 6th, was terrible for our democracy. We think the idea of not having two political parties that believe in free and fair elections is incredibly harmful for our democracy. And what we're focused on, as our name suggests, is holding Republicans accountable.
Now tell us about the 60-second ad. What does it entail?
Sure. So what our ad is all about is explaining to the American people. It's an education campaign, letting the American people know that Donald Trump must be held accountable. There's 91 felonies charged against former President Trump, including in the state of Georgia in Fulton County, which tried to overturn of Georgia when he called Secretary of State Brad Raffensperger, someone who is a conservative Republican Secretary of State, and tried to overturn a free and fair election that happened in Georgia. And we just want to remind voters that this is unacceptable behavior and that the rule of law applies to every American citizen, even former presidents.
Would your organization have launched this ad if the former president had not been additionally indicted here in Fulton County? Did you already have plans in the works to launch this campaign irrespective of what happened here in Atlanta?
We thought it was right to place this advertisement in the Atlanta market because in 2020, Georgia, Atlanta, surrounding Atlanta was at the forefront of our democracy. There was a lot of pressure to overturn a free and fair election. We're seeing all these indictments come against bad faith actors from the area. They tried to overturn a free and fair election. We think that is very harmful for our democracy. But there's another important component of this too, is that a lot of these indictments are coming out and a lot of it can get lost in the news cycle. And former President Donald Trump has done Georgia, Atlanta, and must face.
I'm going to ask you to circle back around and kind of repeat what you just said. We were having a little bit of internet connectivity issues.
Sure.
Kind of circle back and talk to us what you just said a few moments ago.
Can you say the question again? Sorry, just so I understand what I need to say.
Well, I mean, I believe the question was, did your organization already have this kind of ad campaign in mind before the sweeping indictments of 2 weeks ago?
Yeah, our organization is always focused on holding Republicans accountable, including former President Donald Trump. But it became very obvious to us to advertise in the Atlanta market because there were indictments in Fulton County, Georgia, right? That there was this idea that Trump had to overturn a free and fair election in the state. And we wanted to remind voters what Donald Trump tried to do, because the problem is with Trump, he always sucks the oxygen out of the room, and there's always so much news about him and so much drama that surrounds him that we wanted to paint a very clear picture of what Donald Trump tried to do, both in the other indictments and specifically in this Fulton County indictment, and remind voters how unacceptable this behavior is and that no former president is above the law.
Were you surprised by the number of people who were indicted besides the former president 2 weeks ago?
No, I was not surprised by the amount of people that were a part of the indictments that also former President Trump was, because following the November 2020 election, there was this conspiracy out there with both Donald Trump and his allies to overturn a free and fair election. I think that a good sign for our democracy and our country is that a lot of these people are going to have to held accountable for their actions. And I'm glad to see so many of these indictments coming out. Who are these people that really had no good faith intentions, that they just wanted to overturn a free and fair election because the person they wanted to win didn't, that they lost. And it was a free and fair election. Even conservative Republican Governor Brian Kemp thinks so, and so does Republican Secretary of State Brad Raffensperger.
Are you surprised at the amount of support the former president is receiving among his very hardcore devoted supporters, as well as the fundraising totals that we're seeing coming in? I saw a report from Politico earlier this morning saying that the former president had just raked in millions, tens of millions of dollars immediately after his arrest last week here in Fulton County, and is continuing to break fundraising totals. Tell me your opinion about that.
Yeah, it's not surprising to me that people have rallied around Donald Trump following the latest indictments. We do focus groups with Republican voters just about every single week. And as these indictments have come out, and even the Mar-a-Lago raids that happened last summer, the thing that we notice is that each time these indictments come out with Republican base, they rally around Trump. The thing about Trump that he has done he did it back in 2015, 2016, and he still does it today, is tap into this victimhood grievance politics that ultimately animates the Republican primary voter base. He says it himself. He goes, they're not coming after me, they're coming after you, the average everyday Republican primary voter, and that plays with the base. We ask voters, Republican primary voters in focus groups, do these indictments make you more supportive, less supportive, or neutral following these indictments for former President Donald Trump? And a good amount of the time, they say they make them more supportive. Or I remember there's this one person in a focus group who says, this makes me want to donate to him. So it's no surprise that there's this rally around Donald Trump as these indictments continue to play out. And it explains why Trump is in such a good position to once again win the Republican nomination for president.
That leads me to my next question. What will happen well, first of all, let me circle back one step beforehand. Do you think Donald Trump will be the 2024 GOP White House nominee?
Yeah, right now, I can't predict anything, but right now, Donald Trump is in a very favorable position, right? The clear alternative for Republican primary voters has been Florida Governor Ron DeSantis, who looked at his 20-point victory in Florida as, maybe that this is the Trump alternative. This is Trump without the baggage, as a voter said, or Trump not on steroids, but he has faltered out of the gate since he launched in May. So right now, the former president, Donald Trump, is in a very favorable position. But I will just say that as we saw in 2018, 2020 with Trump himself and his candidates that he handpicked and endorsed in 2022 in swing states, they lost, that his brand of politics and himself ultimately turns off swing voters. So Republicans have put themselves in a very difficult position, that it is one thing to win a Republican primary, it is another to win a general election. And so long as these candidates and Trump himself run Trumpward, they ultimately are going to repel swing voters. And I think it make it very difficult for Republicans to win in swing states. So I'd caution Republican leaders that his brand of politics, Trump's brand of politics, does not play with swing voters, even if it does play with the base.
If Donald Trump is the 2024 Republican White House nominee, does he win?
I think it remains to be seen. I think that there is a frustration among swing voters and independents with Joe Biden and the economy. And although there are economic indicators that suggest that the country is doing better, they are still very much feeling it with gas prices, inflation, and other things. But they do not like Trump's brand of politics. These voters that decide elections, like in the state of Georgia, Arizona, Pennsylvania, Wisconsin, they don't like his brand of politics. And that's going to be the open question at the end of the day is, while they do not like Democratic policies, maybe, do they reject Trump because they just don't want the drama? They just don't want the baggage. I think that's the open question, what we're watching for as we head into general election 2024.
We are wrapping up our conversation with Gunnar Raymer, who is the political director for the Republican Accountability Project, which today on Monday, August 28th, launched a 60-second ad campaign in several major markets, including Atlanta, highlighting the former president's more than 90 felony indictments, and also running a billboard in New York City's Times Square. Final thoughts as we wrap up.
No, thank you for having me. And I appreciate you letting you tell our story of how we view it and our perspective. And I will just say that I hope that to Republican leaders and Republican voters that this sends a signal that Donald Trump's brand of politics is unacceptable and that no one